You're on the record.
Thank you. Good morning. This is the time and place set for the regularly scheduled public meeting of the Nevada Taxi Cab Authority Board, Wednesday, April 20th, and the time is 9:30 a.m. I'll call this meeting to order and indicate for the record that Member Rodriguez has been excused because of another commitment today. And I would ask Member Decker if he would lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Secretary Martinez, has this meeting been posted in accordance with and in compliance with that open meeting law?
Yes.
And also, do we have affidavits of publication for consideration of the application for surcharge?
Yes.
Thank you. Agenda item 2 on today's agenda is the taking of public comment. This time is set aside pursuant to Nevada law for the purpose of receiving information, comments from the public on matters that are within the jurisdiction of the board. We may not take action on any of these matters, and we'd like to ask that any member of the public making comment try to limit their comments to about 3 minutes. Is there any member of the public that would like to make comment to the board? Is there somebody online that wanted to? Is there anybody online that wants to make public comment?
Let me just unmute them. I seem to have troubles and move them again. Yeah. This might take a minute.
No, I was going to say, do you have raise your hand capability there?
Yes.
So if any member of the public wishes to make public comment who is attending online, please use the raise your hand mechanism, which is at the bottom of the screen, I believe. So we can unmute you so you can speak, and we'll give a minute or two for that. That way you don't have to open up everybody, Ms. Martinez.
Okay.
Hearing no public comment in the room and seeing no individual in the public that is attending by electronic means raising their hand, we'll close this public comment. If you did get passed over, there'll be public comment at the end of the meeting as well. We're to agenda item 3, which is very exciting, and we're happy to announce today that we have a new administrator, Mr. Armstrong. Give over the floor to you if you wish to make any comments or statements.
Yes, I'm happy to be here, and I want to do the best I can for both the industry as well as to the regulatory scheme of the matter. If anyone that has anything that they want to say to me, door is always open, and anything you say to me will be confidential.
Thank you. We look forward to working with you. And agenda item 4 is a briefing by former or outgoing interim administrator Decker on transition responsibilities. And I have the floor.
Thank you, Mr. Chair. Morning, everybody. I'm very smiley today, not for the reasons you think. It's very bittersweet for me to turn the agency over to Mr. Armstrong because I thoroughly enjoy the agency and I'm proud to have served it. I'm smiley today because as I drove up, I saw a parking lot full of taxi cab authority vehicles and I see most of the agency here. And that warms my heart because that is a message to you, the public, the industry, the board, and the new administrator that there are a lot of good people invested in the turnover from administrator from me to Administrator Armstrong. The agency's here in force to welcome their new administrator. We have an excellent board. We have a thriving industry. The agency's got good press. The employees are relatively happy and engaged. I want to thank all of you, particularly the Director of Business Industry, but for allowing me to serve the agency for the last 15 months or whatever it's been. I've enjoyed every minute of it. I'm excited to pass the torch to Administrator Armstrong. I've met with him extensively since he was selected. He gets it. And I'm happy to continue to serve on the board and help the new administrator and the board and the public and the industry maintain this agency and help it reach its full potential. And I'm very happy to see all of the employees out today. And I want to point that out to everybody else today. Mr. Armstrong, congratulations.
Thank you.
We've been incredibly fortunate to have Mr. Decker working with us to keep the semblance of the agency moving forward when it didn't have a administrator, and we sincerely appreciate your service and the burden that was because you had 2 masters at one time. We are also incredibly fortunate to have Carl Armstrong join us, excuse me. He brings a wealth of experience in various endeavors, both philanthropic and in career settings in state government, and all of those skill sets will be very important as we move forward in the next years. So I'm very encouraged by having tread the water, and now we move forward in a freestyle swim match. So anyway. That takes us to agenda item 5, which is responses, objections, replies, and appeals to the authority from its March 21, 2022 findings of fact, conclusions of law and order regarding Independent Cab's application for 8 subpoenas, which were issued pursuant to that appeal order. The state of the record is that YCS has filed. Lucky Cab has submitted but unfiled. Western Cab has submitted but unfiled objections to the subpoena duces tecums that were issued. Independent Cab has filed a reply. It is for the board's edification. Your packet includes all of the previous pleadings and documents in this matter. The state of the record as it is before us is that there is no motion to quash by any of the interveners who are objecting, but Independent Cab has filed in their response a request to compel. So it is my judgment, and I submit to the board that under NAC 706-936, we have jurisdiction to determine that motion to compel. Given the YCS Lucky and Western may not have, well, did not file any reply. With your leave, unless anybody objects, I'm going to give each of them a few minutes to articulate any reply they might have to the motion to compel. Does anybody object to that process? If YCS Lucky or Western want to make any statement on the record in response to the motion to compel, that we would entertain that now. Morning, gentlemen.
Good morning.
You would state your name for the record and who you represent, and also set forth your reply.
Yes, thank you, Chairman, as well as members of the board. My name is Keith Gibson, attorney for Nevada Yellow Cab, Nevada Checker Cab, and Nevada Star Cab in this particular matter. We've laid, as to the subpoena issued by Independent Cab, we've raised several objections with regard to certain things. Specifically, they've asked for they've asked for Yellow Checker Star's tax returns, as well as which we believe are confidential and proprietary and have no basis for or relevance in this particular matter. The issue is whether Independent Cab has the financial means to operate a taxi company, not whether or not Nevada Yellow Cab or Nevada Checker Cab or Nevada Star Cab has that ability. So I don't believe that information is relevant. We've already disclosed all of the statistics from the Taxi Cab Authority from 2004 all the way through April of 2021, which at that time was when I did the last major disclosure with regard to that, showing which includes the number of rides, revenue, all of that in there. We also have, they've also requested the annual reports that have been filed with the Taxi Cab Authority. Any reports that are filed with the Taxi Cab Authority, although public record, are sealed. And so we object to disclosure. However, if the board decides to issue or require us to disclose those, we want some type of protective order in place to ensure the proprietary nature of that information. And then I can address all of the various requested information, but essentially they've kind of asked the negative of what's the affirmative duty that they're required to prove. In other words, they've asked, many of their subpoena requests ask for documents that show that there's no need for additional taxi cab medallions. And that response, basically, we've indicated that the applicant bears the burden of showing that the Las Vegas metropolitan area needs additional taxi cabs. But I've also included as reference, not only did I object to that, I also said, hey, we've already disclosed the statistics which show that. Now, how I intend to use those statistics, I believe, is a matter of attorney work product, and I don't believe he's entitled to my thoughts as to how I intend to use that information. But I've pointed it to the documents that I intend to rely on to prove that. And similarly, with regard to the 35 medallions will not benefit the riding public, I've referenced the same statistics that we provided. I also raised the same objection, basically saying, hey, this is his burden, not our burden. And I believe that is not necessary. And so as to the objection that they're not fit to perform the services, I basically just raised the objection that that's his burden to prove that they're fit, not that we have to prove that he's not fit. And so we've raised that. That's kind of consistent for the rest of the way, basically just indicating that that's the burden. That's what's indicated in the statute, in the statutory scheme. And so it's not our job to prove that he's not qualified. It's his job to prove that, or Independent Cab's job to prove that they are qualified. Thank you.
Anything else?
That's it.
Ryan Awad for Lucky Cab and Western Cab. We made the same objections, so I don't want to reiterate and prolong things, restate things that don't need to be said. The one thing I would like to stress though was the point on relevance. The first two requests, one was for tax returns, the second was for the report to the TA. I've looked through those documents and my professional opinion, there's nothing in there that would be relevant to this matter. As in our income, an item line for expenses, none of that will really determine whether they have the financial capacity or whether their pro forma is accurate in their application. And again, they're confidential and proprietary information. There's no real need for those to be disclosed, and they assist in no way in this hearing or in the hearing on their application. So with that, that's all I would say.
Thank you, gentlemen.
Thank
you. Carson, if you'd like, give me 5 minutes as the moving.
Mr. Chair, you've got more.
Oh, I'm sorry.
No problem.
No, I'm sorry.
Mark Trafton on behalf of Whittlesey Food Cab, Henderson Tax.
Gentlemen. Yes, please.
We request to be heard since our objections were also addressed in Mr. Carson's response to the authority. Our objections to the subpoena.
Sure.
Okay.
Yeah, you're an intervener, right?
Yes.
Yeah.
Yes.
Okay. Intervene. I'm sorry.
No problem.
Mr. Winter, I thought maybe you were,
Ditto.
I thought you were trying to hold back.
I don't know if I've ever been accused of that.
Okay, well, I just accused you of it, so.
Welcome, Mr. Armstrong.
Thank you.
Interveners first.
Thank you again, Mr. Chairman, members of the board. Mark Trafton on behalf of Whittlesey Blue Cab and Henderson Taxi. I won't reiterate because all of our objections are fairly similar. Just a respectful reminder that the applicant, as the board is well aware, has the explicit burden of proof as articulated in NRS 706.8827 to prove 5 items in the statute. And if those items are proven satisfactorily by the board, then the applicant is granted a certificate. We as interveners, it's already been established, we have a substantial interest in this matter. Hence, we are able to ask questions of the applicant, request documents and whatnot. Basically, what Mr. Carson's arguing in his response is what's good for the goose is good for the gander. But and he tries to argue that we're all parties, we're all the same. But the reality is we're not all the same. The interveners are existing certificate holders. We have nothing to prove, as you know. He has everything to prove. You can, at the actual hearing, you can listen to what we say, or you can choose not to listen to what we say. Whatever evidence we produce, you can weigh it and say it's worth nothing or it's worth something. We are here as interveners, hopefully to provide information for you to consider that perhaps you don't have the resources to dig into like we do. That's what the discovery process is all about. With regard to the specific requests that he's asking for our financial information, specifically our tax returns and our annual reports, which by regulation, as you know, are deemed confidential by this body. That's the essence of our objection to both our tax returns and to the annual reports. Looking at it from a practical sense, would that information lend anything to the applicant in his quest to become a certificate holder? The answer is no. Our financial information it has nothing to do with the operation of 35 taxi cabs that he's hoping that you will grant him that certificate for. He's hoping for 35 taxi cabs to be leased. Our information is not relevant to that. The reason he's asking for that, he says this in his response, is because we're basically criticizing, we interveners are criticizing the pro forma that he's put forth, that we're saying that the revenues are too high and that the expenses are too low. Once again, I get back to my initial comments. You as board members, when we get up and say his revenues are too high, his expenses are too low, you can totally disregard that if you think we're full of it. We have, if we're going to make that argument, we better bring forth some evidence of that. And the evidence is going to be what we've already identified, and that's the witnesses, which he has not deposed, namely our CFO, our general manager of our taxi cab companies. He hasn't deposed either one of them. They're going to testify about his pro forma and why it doesn't meet the standards. But he wants to get into our tax returns, our annual report. Frankly, that's confidential, and he doesn't need that. He'll hear plenty during the depositions and during the argument at the hearing. So I strongly urge you to sustain our objections to the confidential nature of the financial information, and find, even if you find that it's not confidential, that it's not relevant to his application, the burden of proof that he has. With regard to the other objections, Mr. Gibson did a fine job of explaining. He's essentially going through the elements in our objections to his request number 4 through 9. In those requests, he went through his elements that he's required to prove and reversed the burden, if you will, to try to place it on us. Once again, it's not our burden of proof. He has to prove A through E in 706-8827. We don't have to prove anything. It's not our burden. Yes, we have rights and obligations as interveners, but it's not to prove the elements of 8827. And therefore, I also respectfully request that you sustain those objections as well. Thank you for your time.
Thank you. I join with Mark and what was said. I would point out a little bit on the financial information, the tax returns. I saw an argument in the brief by Mr. Carson that we had to do that. And what's good for the goose is good for the gander. It's not very Latin-y for law, but it's the point. I object because there's no way this could lead to admissible evidence. It just can't. I didn't write the statutes. None of you did, but you got to follow them. And he has things to prove. And the tax returns, it's not going to lead to any admissible evidence that I can see. Maybe he can articulate some. Mr. Carson points out that it's the board that determines fitness, financial fitness, operational fitness. That's one of the elements you're going to have to decide, which is true. But since we're parties, we're entitled to get information, and he can help you point out that here's a problem in here. His plan here is wrong. It is the board's determination, but it's also the board's determination for every element of 8827. And since we're parties here, we're entitled to get information. One thing you can't do is take financial information from the applicant and not show us. That is not due process. You can't do that. So I do object to those. If you find somehow, or Brent Carson can articulate somehow, that this might lead to discoverable information, then we would request a protective order on the two financial ones, the reports to the TA and tax returns. The remaining ones, I call them contention. I've done a lot of litigation, and you get an interrogatory request produced from a party. And it is that, okay, prove, give me all the documents that show there's no need or that I'm unfit. Well, that's getting into work product. Work product is a lawyer's decision on what evidence I'm going to put forth, what argument I'm going to put forth. And he's not entitled to that. The way we phrased the response was we objected to work product, but we would rely or reserve the right to rely on any document produced in discovery, which is a fair response. There's nothing wrong with that. And if we don't produce something, we don't get to offer it. That's just the way the world works. I did see he cited a case of Wynn Resorts where a privilege log is discussed. I didn't object to attorney-client privilege. In these kind of cases, like cited here, somebody gets hurt, a claim is made, there's documents, people go out, take pictures, they do stuff. And under our discovery rules, you got to produce that. That isn't what happened here. A privilege log is then required if you're saying, listen, my lawyer said go do ABC, then I'm not going to give it to you and you got to do a log. None of that happened here. This is just, it's a contention discovery saying, give me documents that show I'm unfit or whatever, that show there's no need. A privilege log is not required. It's an objection saying, you don't get to get into the lawyer's head as to how he's going to demonstrate something or negate something. So the objections, though numerous, they are in response to numerous contention requests. And I think they're fair objections. If you got any questions, I'm here.
I'm going to suggest the board we hear Mr. Carson and then we ask any questions collectively with everybody. Are there any other interveners, council? Mrs. Carson.
Yeah, good morning, Mr. Chair and board members, Brent Carson for the record. Along with me is Claudia Hepner, principal applicant for Independent Cab Company. Let me start out with something that Mr. Winter just said. He didn't write the statutes, but you have to follow them. Doesn't NAC 706 .9368 say if you object or want something, you're not in agreement with something in the request for a subpoena, that you have to move to quash the subpoena, not just file an objection or standard boilerplate things. You have to manually set forth in a motion to quash why it would be two things: unreasonable or oppressive. Those are your two objections to a subpoena that was served upon an intervener. Not one word did I ever hear say this was unreasonable. Not one time did I hear that this was oppressive. As you guys can recall, they came to you with petitions for leave to intervene. It was struck down the first time, and then they made an appeal. And they came back before the board and said, let us refile for a petition to intervene. And in that petition to intervene, every single one of them says, if you grant us this petition to intervene, we want to be full participants and participate in all other aspects of this matter. Discovery is this matter. They agreed to you. They came to you and said, if you let me in, we'll participate in discovery, basically, is what they're saying. So when I say, okay, here's my discovery request, nope, I don't have to give you that. And it's my opinion, my contention is that they waived any type of confidentiality when they agreed to become, voluntarily chose to become a party in this matter. Here I am showing, I have to show Exhibit I, which is a pro forma. And we all know a pro forma is not an actual, because there's no way we can actually forecast the future of what's going to be. So what they're doing is saying, oh my God, he doesn't know how to operate a cab company because his pro forma is unreasonable. And I say, well, why is that in my discovery? Well, paraphrasing, your revenues are too high and your expenses are too low. I say, great, show me what you got. Let me make sure I can maybe make a correction, try to do this. I want to make sure that whatever I present to the board is reasonable. So the question is what standard is reasonable? Is it their reasonable or is it my reasonable? I asked them for this information. They're not giving it to me. I don't want them to come before the board at the hearing of this thing and say, Mr. Carson, your revenues are forecasted way too high. Based on what? Testimony? No, that's not proper evidence. Proper evidence would be, let me show it, let me see what you have, and whatever you're testifying to, whether you're right or wrong, I have the right to look at that number and either one, impeach, or to clarify that comment that they're saying. How can I do that? They have to show me what they're talking about. They like these things, put your money where your mouth is, show me it. That's it. Or don't come in here and complain about mine. Those are your two options. Either show it to me or say, you know what, you're fine, it's reasonable. But you can't have both. I'm entitled to know what their testimony is going to be. That is discovery. What is their evidence? What are they going to show in front of you? I need to be prepared. You guys have all talked about, let's put all the information on the table. Let's have a fair hearing. Let's do that. So one, they've already made it relevant because they're telling me my pro forma is unreasonable and that they're saying expenses are too low and revenues too high. Show it to me. If you don't, then fine. Then don't talk about it. But now, confidential, I believe that they waived it because of the fact that they voluntarily agreed to be a party to this proceeding. They told you that they want to participate, fully participate in all aspects of this hearing. Again, discovery is part of that. So let me talk to you about what they want to call my contention requests. I just asked for evidence that they're going to produce, documents, whatever it is, that shows, I laid it out pretty well. I thought that there's no need for additional medallions. It won't unreasonably adversely affect us. And I get objections that based upon a burden of proof. Well, I know my burden of proof. It's clear, it's written in the statute, the statute. But what I'm also entitled to know is what evidence they are going to present that says I'm not. Is that not a surprise if I show up and say, hey, guess what? There's a felony rap sheet, or something like that. This isn't a surprise gotcha moment. All I'm asking for is if you have any documents that show there's no need or there's not a fit operator, I'm not operationally fit, show me. This can't be a surprise. And the burden of proof isn't even an objection. I mean, if you just said, oh, it's on every discovery request, it's your burden of proof, I don't have to respond. There would be no discovery. It'd be over. I mean, what else can I do? Oh, it's your burden. Every lawsuit, litigation, administrative hearing, everything has a burden of proof, whether it's criminal, beyond a reasonable doubt, whether it's preponderance of the evidence or whatever. Everything has a burden. You can't just object and say it's your burden and I don't have to show you what I've got. I don't think that's where we were going on this administrative hearing after the last hearing that we had. Mr. Winter mentioned work product as a defense.
Objection.
Yeah, sorry, as an objection. I don't agree with his rationale of the Wynn case. I think clearly attorney-client privilege is protected, but work product are, in my understanding, is documents prepared in anticipation of litigation, whether it was. That's what the Supreme Court says. So if there was any documents that were prepared and he's claiming a privilege, there has to be a privilege log that would show why this document is protected. I doubt there is any because Mr. Winter did produce a couple pages of documents attached to his subpoena request. If that's all they have, I need to know that. Just answer the question. If it says, let's just for example, produce documents that there's no need for additional medallions, there are none. Just state that. If they don't have any, state it. That's fine. So if there is a document, the document A, and it's subject to the work product because of A, B, and C. I don't need to see it. So as long as you guys know that it's out there and it's subject to some form of viable objection, then at least let me know what it is so that I can determine whether or not the claim is valid or not. You just can't say work product and then say that one page that he's objecting to, is that 100 pages that he's objecting to? I just don't know. But you have to be able to identify the document to determine whether or not the claim of privilege is a valid claim. So basically, that is it in a nutshell. I mean, there is no motion to quash. There's no objection on unreasonable or oppressive. They're just sitting there saying, we don't need to give you these documents. Based upon the motion, I think I've clearly laid out, one, relevance, the confidentiality is waived, and two is that burden of proof is not an appropriate objection. So thank you for your time. If you have any questions, I know you wanted to.
Thank you. Mr. Gibson and Mr. Haywald, if you would come up and sit up there in case, be up in the front there in case some of your colleagues have questions of you. Thanks. Member Becker, I'll begin with you if you have any questions or questions.
Sure. So respond to a couple of the points brought up. This is an administrative hearing. I wouldn't be inclined to penalize the parties on technicalities, nor do I agree with some of the characterization of 706.926. However, it can be assumed that any objection made by the interveners under that statute is an intent to or to rule in accordance with the statute, whether it's stated that way, pleadings or not. However, so it seems to me there's two categories of information being requested. One is evidence. I mean, the interveners are assumingly adversarial to the board approving the application. So at some point, they assumably intend to present some evidence to the board that supports that position. That's one category, which let's see. Second category is confidential financial information. So I'm inclined to kind of state that context. I don't necessarily have any questions, but I would maybe ask Mr. Carson what, if he's got a justification for the confidential financial information, if it's not intended to be produced against him from the board.
Say that again, because I think I understood it, but I don't want to answer the wrong question.
Confidential financial information that you've requested from the companies, is that material to you in some way if it's not data that they intend to present against you?
Well, I think, yeah, I think that's the remedy. If they don't want to produce it, then I don't think they should be able to question the reasonableness of my program. Does that make sense?
Because but in fairness, Mr. Carson, that wasn't the question.
Oh,
The question was, if that evidence, their tax returns, their financial reports are not going to be presented as evidence against your pro forma, why do you need that information? I think that's the question.
Well, and I don't know if I answered that correctly then, because if, like I said, if they are not going to question,
That's a matter of questioning.
if they're not going to,
If they're not going to produce
present.
that, you've asked for certain documents.
Correct.
If those documents are not going to be used as evidence against you, why do you need those documents?
If they're not going to be used against me, then I don't need them.
Thank you, Mr. Chairman. First of all of this use of the term, what's good for the goose, good for the gander, my mother used to say that a lot when I was a little kid, so that gave me a smile. And I think I've said in a previous hearing, that was my philosophy going into my first big PUC case with some of the same parties and same individuals that are in this room. And when I try to put forward that philosophy in these types of cases, I was reminded over a number of years by elected officials that that's not the policy of the state. And why am I even bringing it up? So my mind was changed after a few years that no, this isn't what's good for the goose, good for the gander, because the goose is asking for something from the state that they are not generally entitled to as a matter of right. And the philosophy of the state is those in certain industries, the existing members of that industry have a right to question that in their own interest. The financial health of the existing industry is part of the regulatory philosophy of many agencies in the state. And that the public is best served by a healthy industry is something that is always should be on our minds. Having said that, when I look at what is being requested here, I'm a little confused, and so I'll have questions. Mr. Gibson, yours was the first in our packet,
That's fine.
but everybody's answer is completely the same. I don't know if they copied you or you copied them, but either way, it's substantially the same. And I'm looking at essentially answers to request 4, 5, 6, and 7. And you state that you do not have the burden to prove what the applicant is asking of you or the support for your contention. And I believe you're correct. But you also seem to be saying you've got nothing and you don't have to bring anything forward. Is that what I should understand, that you're saying, well, I don't have to have any evidence of this because it's not our burden? Or are you saying it's not our burden, so I don't have to tell you if I have it? That's two different things.
I think that's a mischaracterization. If you look at, for example, request number 4, I provide my objection and then I say, subject to that objection, see all of the statistics from the tax cap authority that I disclosed, which was about 1,000 pages approximately. So I've disclosed, and so I indicated, see these documents. He asked for the documents that I intend to rely on. I said, see these documents.
Right.
So I provided that explanation. And so even though I made the objection, I actually went, to protect and say, hey, look, see the subject to this objection, please see these documents, because I believe the documents that I pointed him to has an indication that supports The information, as far as how I intend to use them, is, I believe, protected at this point. But as far as number 4, number 5, number 6, and number 7, or number 4 through 6, for example, that I'll ask about whether 35 medallions, is going to have any, basically, to combine them all, have any impact on the industry. And I've pointed him to the statistics of the tax cap authority. So I've answered his question in this instance. Now, as far as the others, I just laid out the flat objection. I can certainly, add a caveat to that if I have any documents responsive to that, I can supplement, say, I have no documents responsive to this request or something to that effect. If the board overrules the objection and compels the answer, I have no, for whatever documents I do have, I would disclose those.
So what I understand you saying in these responses, and please, the other parties, if I have mischaracterized your position, please let me know. You're saying, we don't have the burden. We don't have to produce anything that we haven't already produced. Take a look at that. But you're also saying, we don't have something else we're hiding from. Is that correct?
Yes.
Your head nodding?
Yes, that's
Head,
correct.
second nodding. Mr. Winter shaking his head. He does not agree with that statement.
No, you're close, but I'm sure without waiving attorney-client privilege, you can imagine that I've spoken to my client, and there may be documents in our files that would assist or help in an argument saying there's no need for these, there's no fitness. But have we produced them yet? I don't know. We have produced some things, and if I produce something else, it will be in the form of a general production. What I won't do in the production is say, these 3 documents here show you're unfit, or show this is unreasonable, or something like that. It will be production, and at the hearing, we'll decide what we're going to argue. Like those 3 documents Mr. Carson referenced, I understand what they mean because I've spoken to my client about that. But I didn't tell Mr. Carson that. We just produced the documents. Is that fair?
I think that's fair. I think that's my questions. I don't know if this is the time for arguments, or should we ask questions and then I'll keep going with questions right now?
Right.
Okay, that's all my questions.
Thompson, do you have?
Well, let me say that I spent most of this meeting trying to figure out what you were talking about.
I've heard that before.
80% of what I've heard has been legalisms, which I'm certainly not an expert with. It seems to me a request for tax returns and annual reports may be more vindictive than useful, but I don't know. And so I'm inclined to say this 80% I will leave to the attorneys on the board. Now, I've heard a couple of times a statement that Mr. Carson's company's revenues are too high and costs are too low. Now, it strikes me, unless there's something nefarious going on there, this is excellent competitive advantage. I don't know what to make of that, other than maybe that's great. And so I'm inclined to say, well, I don't know what I'm inclined to say, to be perfectly honest, because 80% of what we're talking about today devolves on legalisms that our attorneys can invest to look at. I'm not so sure that Mr. Carson's company is as nefarious and bad for the industry as we're hearing here, which may be just simply competition. I don't know. I need more information about that. So I've not explained anything very clearly or asked anything very clearly, but I think I've done enough here.
Okay. to the interveners, yes or no, do you agree with the following proposition? And this is a follow-up to member Soderberg's point. On requests for production 4 through 9. To the extent those requests are interpreted as asking you for any documentary evidence or the identification of a witness that will provide evidence on those points, he's entitled to know that. On those points of the statutory elements he has to prove. Subject to, because I agree with Mr. Winter, he's not entitled to you to tell him your tactical attorney-client discussions, your tactical manner in which you're going to present the case, or your impressions. We're just talking about these 2 documents and these 2 witnesses. Is anybody, just tell me yes or no, that's a correct assumption?
Yes.
Yes.
I would agree with that, but we're grouping them all together, right?
4 through 9.
Yep.
Yes. Mr. Chair, could I add to the extent that any additional witnesses or documents will be excluded by the board? That confident at the time of hearing?
Certainly. And so your question is, so you understand that the result of that answer might be you won't be allowed to present that evidence if you held it back. And I think Mr. Winter already said
That's law.
fair under 233B, right? Under
That's the law.
administrative rate. Yeah.
If it wasn't produced, it's not coming into evidence.
And unless we somehow make a determination under the APA that we're going to let it in under the jungle ball rule. I'm just saying there is that rule where agency can let something in for whatever purpose, but yes.
So consistent with this discussion we're having, would we be, I can't think of anything specific on my end.
I'm going to go a step further.
Okay.
And so that nobody gets caught flat-footed, would you agree that if you were granted 10 days to supplement your responses, you could achieve that?
That's exactly what I was going to ask for. So yes.
Mr. Gibson?
I'm pulling up my calendar just to see what my next 2 weeks look like.
I'll come back to Mr. 10 days.
I'd ask my client first, if that enough, 14 days. A timeline, sure.
And it should be a thing.
I think 2 weeks, 10 business days would be appropriate.
I'll just share with the board as chair my analysis of this, and then I will entertain any further discussion or you want to consider. First of all, I don't believe that there's a jurisdictional issue, which I think is Mr. Carson's point, that if there's no motion to quash under 706-936, we don't have jurisdiction. We entered a very fulsome order last month, which retains the jurisdiction of this matter, because I think the sense of the board was, let's get this discovery business behind us and set this for hearing. And we, I think, maintain jurisdiction to hear this in whatever form it came to us. Nobody moved to quash. There are objections, though, and you moved to compel, which is the other side of a motion to quash coin. And so I think we have jurisdiction. So I don't think that issue is well taken. On the objection to requests number 2 and 3, which are the financial data, I don't view, and I think I hear my fellow board members in concurrence with this, that the financial position of an existing CPC and holder is relevant in any way, shape, or form on the financial position sufficient for an applicant to show they are fit, willing, and able under the statute. That is a peculiar issue to the applicant, who must establish their capability of operating whatever the CPCN will grant them to operate. The income tax returns or financial positions of an existing CPCN holder don't go to that issue. They are, in my view, not likely to ever present any fact, the truth of which would change the result in a hearing under the evidentiary standards of 233B. So it would be my recommendation that the objections to request number 2 and 3 be sustained. Or stated differently, that the motion to compel those be denied. As to objections to request number 4 through 9, I don't think that, with deference to the interveners, all who are represented by able counsel, I would agree with Mr. Carson. Burden of proof is not a response to a document or discovery request. What is a response is, I've given you everything I'm going to produce on this question. And you're not entitled to know how I'm going to present that, when I'm going to present it, or with what evidence I'm going to present it. That's my theory of the case. That's why clients hire and pay lawyers. And so I'm kind of splitting, in my view, the baby between the two parties' positions. And I would be inclined to grant that request to compel in the following way, which is to grant 20 days to the interveners to supplement their responses to 4 through 9 with any additional documents, physical evidence, or identification of the witness that you would use on those matters. In that connection, though, it is not my intent to suggest that there's going to be another round of depositions. If you didn't depose somebody, you didn't depose. That I don't think is a fair extension of that. It does also give the board a sense of who and what evidence they're going to be hearing on those particular. So that would be my suggestion on how we resolve this dispute before us, but I'm happy to bring this back to the table and have a discussion on it.
Mr. Chair, I agree with you 100%. I would add that I can't, I'm just going to mention that I can't see the need for number 2 and 3 or why it was requested other than some kind of retaliatory manner. But worse than that, it's distractive for Mr. Carson because it distracts from the process of getting his application processed and was unnecessary in the first place. So I just want to make mention because we spent a lot of time on that and we're closer to getting Mr. Carson's application processed because of the information requested. So, and the second thing is I'm a little concerned about the responses of industry. So I'll mention this. They bring up burden of proof in their responses. And I will state for the record that they have a burden of proof if they're going to allege that Mr. Carson is not fit. And so this idea that there's no responsibility on their part, I want to mention that I do not see that as the case either.
Well taken.
Thank you, Mr. Chairman. I agree with both your comments and Member Decker's comments. Mr. Carson, you suggested that once the interveners were granted their intervention, they waived all of their rights to confidentiality. And I think I heard you say that. And I just don't see it that way. they're still certificate holders. Your client is not. And if your client is granted a certificate, I'm sure they'll see it that way the next time we come around to this issue. So items 2 and 3, that's clear that's a denial. I'm surprised that was even asked. Really, the only people in this room have a right to ask for that sit over here. The regulators. 4 through 9, Chairman, I agree with you. It is true that the applicant bears the burden to prove all of these items. But it's also true that surprises are just a bad way to do business, and it's unfair to the applicant or to any party if they're going to be surprised at the last minute with something new. And it administratively just makes for a bad hearing, and it gets in the way. So I think, although you've crafted sort of a motion that grants the motion to compel on 4 through 9, I think what we're really saying is, okay, that's fine, but if you've got anything else, you've got 20 days. So there are no surprises. Member Decker gets his unofficial law degree. The applicant has the burden of proof. Well, if somebody is going to try to prove that in the negative, they have the burden of proof of backing up their claim. Clearly, an applicant could come and has the burden of proof and nobody could bring evidence against them and they could still not meet their burden and not get an approval. I've seen that happen many times in my career. So they don't have to affirmatively claim anything, but you always have to back up what you're claiming. And I think what you've come up with, Mr. Chairman, is fair to all the parties. Get everything on the table. Clearly, we don't need to know attorney strategies. We don't need to know attorney-client type discussions. But if there's going to be a witness or another document and all that, it shouldn't show up at the hearing. And in my experience, when those things happen, you just look back and you're going, that hearing didn't go well. And I don't have a good record here. Everybody was surprised. Nobody could use this or try to contradict it. And it just isn't a good way to run a hearing. So I think what you've done here is come up with, I would call fairness. A fair hearing that does not shift any burdens. If there's nothing new, there's nothing new. Applicant still has the burden. And we'll see how that goes. But in the meantime, we'll have a good hearing that fleshes out the issues and everybody has an opportunity to make their case.
I will say that I have heard everything that the board members have said, and I agree with that.
Just one comment before this, because you said
We're
about,
we're at the table, we're in deliberation.
no, I mean,
There's
it
nothing.
was about the depositions, because I had noticed depositions and I took them off pending your guys' decision. You said I didn't want to open up a round.
So I will entertain a motion. Can I suggest, and our Deputy Attorney General can tell me if I'm overstepping how this is agendized, that the motion also include that after the 20-day period is run, this matter be remanded to the hearing officer to make final resolution of any discovery issues and other pretrial matters, pre-hearing matters, so that we can get this back on to a hearing schedule.
You got a thumbs up.
Yeah.
I got a thumbs.
Yeah.
We need a screen back here.
Okay, thank you. Okay, I would entertain that motion. Those motions, or do you need me to restate them?
I would request that the chair,
Restate?
well, the chair make the motion. If that's
Okay,
appropriate.
That might be the best thing. So
Okay.
nobody fights over what we
okay,
voted on.
very good. I would move to deny the motion to compel on requests number 2 and number 3. I would move second that we grant relief on on the motion to compel on items, requests 4 through 9 by extending to the interveners period of 20 calendar days in which to supplement any response they wish to 4 through 9 as to any evidence they intend or witnesses they intend to produce on those items and elements of the statute that are identified in 4 through 9. And that after the 20-day period has run, that the matter be remanded to the hearing officer for a pre-hearing conference to resolve any remaining discovery issues and pre-hearing obligations such as filing exhibits and whatnot, which would be in the normal course, and recommend to us a hearing date.
Mr. Chairman, I would second your motion, but I do have a clarification question.
Sure.
I just want to make sure it's clear on items 4 through 9. The board is not telling the interveners they have to produce something. They only need to produce it should they intend to bring it at hearing. They do not have the burden to bring any of these should they choose not to.
Clarification of that, the intent of that is correct.
And
Yeah.
I second the motion.
Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Thank you, gentlemen.
Thank you. Thank you.
Everybody okay to keep on ordering through?
Yeah.
It's been an hour.
I still have coffee.
Stuff. We're to agenda your agenda item 6, which is public hearing in the matter of the application to amend fuel surcharge for taxi cab rides. The applicants are Henderson Taxi, Little C, Bell Taxi, Nevada Yellow Cab Corporation, Nevada Checker Cab, Nevada Star Cab, Blue Desert, and Desert Cab under the application filed by council on March 30th. So there are intervention requests from YCS Acquisition LLC, 21st Century Taxi LLC, Cab Transport LLC, Taxi Transport LLC, all filed April 1st. Good morning.
Good morning, Chair, members of the board. For the record, I'm Kimberly Maxim Rushton with the law firm Cooper Levinson, appearing on behalf of the applicants. I'd like to begin by welcoming Administrator Armstrong. We look forward to working with you in the future and appreciate your vast experience and know that it'll be welcome in this industry. Thank you.
Thank you.
Chairman, before we begin, late yesterday, I supplemented the application and filed some statistical information and some financial calculations. In addition to those being provided to you in advance, I also brought copies for members of the public. So just wanted to make that known if anybody would like to see that. By way of background, the application before you is a request to amend the application, or excuse me, the order of this board from 2015, which specifically authorized the imposition of a fuel surcharge and the authority of the carriers to utilize that as part of their meter rate. In 2021, that request was brought forward again to this board and asked that that order be substantiated or be further authorized so that the carriers could utilize the fuel surcharge. And so the application before you is really a continuation of that, but a request to expand the tiered rates and then also have rates that are applicable specific to the zone rates. The basis of this are the increasing prices in gasoline that I know everyone is aware of. In addition to that, it's the increasing cost due to the inflation that the United States is currently experiencing. In an effort to demonstrate the objectiveness of the gas prices, I did include in the application a study from the Pew Research Center, which I think demonstrates the fact that there has been an ongoing and steady increase in the price of gasoline prices. But what I would point out as being unique to this particular set of gasoline prices and why it is not addressed by the current order is the fact that we're now seeing spikes that are not just momentary spikes, they're continuing spikes. And so with no consistency with what we've again seen in the past. And so in an effort to recognize those spikes relative to the prices of gas and the other costs that carriers are incurring as a result of inflation, we brought for you an amended application and ask that you consider, review, and approve a new tiered system, which would allow the carriers at a certain 14-day threshold to implement the new fuel surcharge based on the cost of gas. Again, the objective standard is that put out by the U.S. Department of Energy, specifically identified as PAD 5 and the regular fuel cost, which I would note that I looked up this morning. And as of Monday, the regular cost of gas, according to PAD 5, U.S. Department of Energy, is $5.95, or excuse me, 5.095. So we're already creeping up into the tiers that we're asking you to consider and contemplate today. And so with that, I'd like to invite those participants that are with me today on behalf of the companies, Mr. George Balaban from Desert Cab and Virgin Valley, Cheryl Gibbons from Whittlesey Cab and Henderson Cab, and Mr. Michael Balin on behalf of the Yellow Choco Star companies to provide additional information about the direct impact that these spiking gas costs are having on their companies and the necessity of approving the application before you.
Thanks, Ms. Rushton. Before we go further, thanks for setting the table. I just want one procedural matter. We do have the intervention requests of a number of parties. Do any board members object to me granting those interventions? No. That'll be the order of the board.
Thank you.
Since one of the interveners is standing.
Mr. Chair, procedural,
Yes.
at some point, whether before the interveners or after the interveners, I might ask the administrator if the agency has a presentation.
We have provided information under this item number 6. One of the things that we wanted to, we looked at the. I'm sorry.
You have a presentation, but I don't think we want to do it yet. I think we're going to let the
Yes, okay.
applicants go first, and then we'll have staff weigh in, if you don't mind.
Well,
So if I could direct your attention specifically to the supplement that was provided, that gives a breakdown of the cost and the proposed tiers. And with that, if it's acceptable, I'll turn it over to Mr. Balaban to walk you through the specifics.
Good morning. Could I have a question here?
Sure.
Some of the companies are using natural gas for their fuels. Is that not correct?
We use propane, sir.
Okay, how is that priced? I didn't see that in her analysis.
So can I suggest we hold questions and let them
Sure,
do their affirmatives first?
absolutely.
Because they might answer some questions we all have, and then we can,
Okay.
then we'll come back to that. So go ahead, George.
Good morning, George Balaban with Desert Cab Company. So as Kimberly has stated, we kind of gave you a little cheat sheet there because I wanted to go through some of this math so you understood what it is that we're doing.
And when you say cheat sheet.
Yes, I'm sorry. Yes, yes, this memorandum. So going back.
Just for the record, I'm gonna have Mark, for purposes of identification, this document, which was dated April 19th. It's a memorandum to the authority from Rushton. It is 1, 2, 3, 4, 5 pages. Everybody has that. We're going to mark that as exhibit 1 to the application.
Thank you, Chairman.
You can put it in, Rushton.
Thank you. Yes, sir.
If you want to move it in.
Yes, sir, I will. We'd ask for
Any
that.
objections to receipt of that? Exhibit 1 submitted.
Thank you.
So some historical first. The last fuel surcharge that we had put out a $1.20 tier. It was gas over $3.25 all the way up to $4.45. I believe that the length, the size of the tier, which the whole $1.20 change in the price of gas, is put in there for reasons that it's a big process to come in front of the board to ask for a fuel surcharge. So you don't want the range to be so small that we're coming in, asking for it, taking it back off. So that's some context as to why the range is so large. The second part is that we always have to remember that as we're doing these things, that we are constrained by the meters that are in the cabs. So like right now, our rates are, because of the 20-cent fuel surcharge, are $2.96 a mile. That is divisible so that we have a certain increase per mile. As we grant increases, if we were at 296 and we went to $3.16, that's not divisible by any numbers to get an even number. So we have to go to 317 isn't, but 315 is. So if we were to increase 19 cents, we have a number that's divisible so that we can increase the meter every 9th of a mile or every 15th of a mile. So that is also a parameter in here that makes it so that we can't just have it so clean to say it's 20 cents each time. So that I wanted to put that context out there. How we've come about this is and this is kind of on the cheat sheet. We look at the industry statistics in our group, and the average trip that a cab takes is about 4 miles. The average paid mileage percentage, which is the amount of miles that the car has a passenger in it, is at about 50%. So what that means is that while the trip takes 4 miles, it takes another 4 miles to find the trip because half the time you're empty. So in essence, every trip is 4 miles to find it, another 4 miles to fulfill the trip. So that is one of the things that's on here, that we have a 4 mile trip, we have a 50% paid mileage percentage. The next piece is that when we look at our fleets, the miles per gallon of our fleets is in the 14 miles per gallon range, which seems low, but again, it's city driving, starting. It's not like it should be if you were on the freeway or something. So as an industry, again, the Cabot group, the ones that applied, we're at about 14 miles per gallon as a fleet. It varies a little bit, but it's in that range. So we're looking at the fact that it's going to take, a trip is about 8 miles because of the 50% paid miles, and we're getting 14 miles per gallon. If you divide those two numbers, that means it's taking about 0.57 gallons of gas to provide every trip that we do, to find it and actually do it. And so we come up with that 0.57 numbers of the gallons of gas. We apply that to the $1.20 range that we have, and that's how we're coming up with that we wanted this 20 cents. So if you look at it, the tier range is $1.20. If you take the 0.57 gallons of gas times the $1.20 range, means that if there's been a $1.20 increase in the price of gas, that's going to cost us 69 extra cents for every trip that we fulfill. Okay, that's picking the whole $1.20 range. So in this situation, on your cheat sheet I put in front of you, I use 20 cents per mile as what we're asking for. This first tier, we're only actually asking for 19 cents, but we're on average going to be asking for 20 cents a mile in this separate tiers that go above it. But let's just stick with this tier. So we're requesting 19 cents per mile. And if the trip is only 4 miles long, that's going to mean that we're going to collect 76 cents on every trip. That's how much money that we would get. And again, if you're looking at we told you it was going to cost us 69 cents in gas for every ride that we take. We're going to now collect 76 cents. So we're making an actual 7 cents over just the price of the fuel, which is, again, we're collecting a little bit more than what the price of the gas has been. We feel that takes into account not just the price of fuel, but some of the other costs that have come to us as others pass on fuel surcharges to us. So while it's not exactly the number, and again, we have to remember, again, because of the rules of the meter, we can't figure these things out exactly, but that is the math behind how we're coming up with this tier of asking for 19 cents a mile. Raise the rate from $2.96 to $3.15, and that will create a whole new tier, which will cover the price of fuel from $4.46 I believe, up to $5.65. So, which is the range we're in right now. The price of fuel, others are going to address, but the price of fuel went over the $4.45, our last year, back on March 7th. So we've been 45 some days. And if you looked at what that has cost us, it's roughly $5,000 a day in our rates, of which, again, a good chunk of that, more than half of that is going to the drivers. So it's a large amount when it's taking this long. That is one of the reasons that we're asking now, and it's going to be addressed by others as well, that we don't wait 30 days, that we are going to try to ask to have this thing done if the price of fuel is getting up over one of these tiers in 2 weeks. Because again, waiting during this time frame from March 7th till yesterday, when I did the last calculation, my company's used 125,000 gallons of gasoline. And again, with the price of gas where it is above this last tier, it's again, it's $5,000 a day. It's a very large amount of money. So we're looking for, well, so if you look at the, basically using the math I'm doing, the next tier that we would be asking for is, hopefully gas does not get here, but so that we could act on this now. The next tier is from $5.66 to $6.85. So once again, we would be moving from the $3.15 up to $3.36. So it's a 21 cent in the next tier, again, to make the meter work. All the same formulas all work. And then the last tier, because we're here and we're doing it, God forbid we ever get to that price, but is from $6.86
to $7.
Well, that's not $1.20. That's a typo in there.
Yeah, 706.
No, it's going to be $1.20, the 7.91.
7 what?
81.
Oh, for the 24 cents.
No, yeah, the next, you're gonna have to add $1.20 to it, so it would be 806.
Mhm.
Yeah. So there's a typo in there. That third tier,
Let's
This was-
correct the typo.
Yes.
On page 2 of the application,
yes,
So
at
it's-
line 16,
yes,
should be corrected from $6.86 to $8.06.
6 cents.
I apologize for that. And again, the differences in the increases from 19 cents in the first tier, 21 cents in the second tier, and 24 cents in the third tier have all to do just with the meter and trying to get a divisible number that will work.
Actually, that's actually the fourth tier, right? Because
Yeah.
we're on the existing tier.
We haven't, I'm sorry, yes, Chair. We also feel that while that last one at 24 cents is getting considerably higher, if gas is up in that $7 a gallon range, the costs that are going to be put onto us from all of our other suppliers is going to be significantly, I mean, we're in a whole different realm there. I'm sure we would be back in front of you, not even talking about a fuel surcharge, talking about just a general rate increase or something, if God forbid gas gets up there. So that is my presentation, and I believe Cheryl has some comments for her company.
So why don't we ask questions of individuals as we get to them, so we don't. So if you have questions of.
Sure. Mr. Belvin answered my first question about the odd dollars and cents number, so thank you for that. Can you explain for the board, page 3, you mentioned that the increase requested will assist taxi operators in maintaining drivers. Can you outline for the board how specifically that is?
Yes. Again, I'm going to speak for my company. We have employees as well as these drivers. Our employees' wage is determined by the price of fuel. So they participate in the cost of the gas. So it's coming off the book. So any increases in the rates will be passed along to the drivers that are employees. To the lease drivers, it's 100% theirs because they were paying for 100% of the fuel. So basically it's an increase. So their costs have gone up like everybody's have gone up, and this will pass through to them, which is going to make the job a better job, which is going to allow us to first get more drivers and retain drivers.
No other questions? I have no question.
Well, I've got a peripheral question for you, Mr. Galavan. I understand that the rideshare rates have gone up so that they're pretty well comparable to the taxi rates now. How would this increase in fuel charge affect that? Would it make us more expensive than the rideshare, the Ubers, the Lyfts, et cetera?
Well, I don't control their rates or their surcharging. Their rates have come closer to our rates. They're struggling to get drivers just like we are. My understanding is you know, from people in the industry that the drivers that were the TNC drivers during the pandemic, a lot of them left, but the ones that came back started to work for the delivery companies, the Grubhubs of the world, the DoorDashes of the world, the Drizzle that delivers alcohol, all these different things. They found they've made money and they don't have to deal with nasty customers. They get sick in their car. So the actual Uber that moves people around are having a hard time getting drivers. They're reacting by raising their rates. And that is why they're getting closer and closer to us. The reality is that if we don't raise our rates, I'm afraid we're going to lose our drivers to them.
So, I mean, what you're saying is that our rates are still going to be a bit higher than the TNC drivers.
If they're not in a surge, yes. But I believe that right now, because they're struggling for drivers so much, there are a lot of times that their rates are actually higher than our rates and still will be higher than our rates based on what's going on in town. I mean, that's just the reality of it. There'll be some certain times that they're not. And the smart customers are looking at those things and picking where they think it's the cheapest. But we're way more comparable than we were. Yes, sir.
Thank you, George.
Mr. Balaban, on Exhibit 1, what is you're recommending 80 cents, correct?
Well, in this first tier,
In the first tier?
we're recommending a 19 cents per mile.
Yeah, which
And
generates 80 cents.
76 cents, yeah. So that 4 mile times 19 cents. I use 20 cents on this cheat sheet because that's kind of the average of the tiers, 19 cents, 21 cents. But it's in this first tier, it's actually 76 cents. Again, it's an approximation of the mileage. The 19 cents is a real number though.
Okay. And so it's actually generating 76 cents. Is that what you're saying?
If the trip is 4 miles.
Right.
And the meter's on and it's 19 cents a mile, yes, it will generate 76 cents.
So when on Exhibit 1, where it says basis for proposed tiers, is this an average number down? Is this an average number what you're telling me?
Well,
When you say 80 minus 69 equals 11?
Yes, Chairman. So what I did was that in the very first, now called the second tier, this tier we're asked for, we're going up 19 cents.
Right.
The next tier, we're going to ask to go up 21 cents against because of the meter. So yes, I used the average between those two and used 20 cents on this calculation.
So is it a correct conclusion that the average, I'm not using this as a pejorative, but the average over recovery is 11 cents. That's an average.
Between the
three
what we're
tiers.
called tiers 2 and 3. I did not put the fourth tier in there, hoping the gas didn't get to $7 a gallon. I was just using these first two because I thought those were the most realistic that we could get into. If that makes any sense.
It does. Then that the analysis that we have on Exhibit 1 doesn't really help us understand the 24 cents.
Correct.
How did the 24 cents get?
But the 24 cents would be.
It's okay if you say you pull it out of the air.
No, where'd the 24 cents come from?
Yeah.
The 24 cents came from me trying to get a number that was divisible to use on the meter. That's all.
Oh, okay. That was over 21 cents. It was more than 21 cents.
Yeah, I couldn't use 19, 20, 21. I was trying to find a number that would work.
So that's the lowest number above 21.
And I don't remember off the top of my head, but I looked at 18 and 19 to go the other direction. So I believe that it was anywhere between, I don't remember how low I went, but I went and looked at 18 because I know I've been at 21. So it's the lowest number above 18 cents.
Okay, that's
Okay.
visible.
Yes.
Take it away.
As usual, I'm going to play the historian in this room, and because we do have some new board members, considering the length of time that we've been around. So I just wanted to give you a little history on the fuel surcharge. During the last, the 12-year period between 2003 and 2005, there are 19 separate board orders addressing just a fuel surcharge for our industry. The last board order was issued in August of 2015, which this board then turned around and said, yes, was still in full force and effect. The only change to that board order versus the other 18 was that instead of us having to come before the board and have a whole hearing to get the fuel surcharge adopted, it was done automatically. So it could be automatically put on and taken off. But the 30-day threshold was still there. At those years prior, there was a huge expense involved with the tax cab authority whenever there was a change to the meter. In May of 2007, TA staff testified that any change to the drop on the meter cost the taxi cab authority itself $12,000. And it took them 30 days to accomplish this task. I do have the May 2007 board order that has that testimony in it, if you would like it for the record. Kelly Cusack testified that any change done to the mile would be a cost to the authority of $24,000. This was because they had to not only order meter seals, wait for the meter seals to arrive, then literally take every taxi cab in Clark County, drive it the mile, and then reseal the meter. This was just the process during those years. Thankfully, the companies and technology have changed. We have invested in smart meters, which now allow for meter rates to be done electronically and for the authority to oversee those changes and monitor those changes without having to physically come out, drive each cab a mile in Clark County, and physically reseal that meter. So the reason for that 30-day threshold in those fuel surcharge orders over the last 12 years is no longer relevant. So that's part of the reason why we're asking you to do the 14 to 15-day mark on each of the tiers to give us a better chance to respond in a timely fashion. Having said that, the tiered system allows us to rapidly respond. I don't think anyone in this room could have anticipated that fuel costs would have risen to the levels that we see right now, nor did we anticipate them changing this rapidly. As such, the board order from 2015, we didn't anticipate fuel going above $4.45. And now, as we've seen, it's gone far beyond that. Since that threshold was reached at $4.45 on March 7th, my companies have driven over 990,000 paid miles, which on the surface sounds like, a lot of miles, but at the same time, that's $198,000 in revenue that's been lost. Not just for me, but for the drivers that I employ. Because employee drivers at my company share in the meter at a 50% rate. My lease drivers would share in this 100%. I wouldn't see any of that revenue change. That would go directly to those lease customers. But my employee drivers would be receiving 50% of that revenue. So it is a tool to not only attract, but to retain the drivers that we currently have in our fleets. The vast majority of people that are coming to apply to work for me are former Uber and Lyft drivers. They're coming to me because they don't want to have to pay for all the gas and the wear and tear that they're seeing on their vehicles to have no support whatsoever. And when people get sick in their cars, have to pay to have it cleaned themselves. All of the things that we provide them as an employer or even as a lease customer to us, they get all of those same services. So it's more beneficial for them and saving them a lot of money, especially on their personal vehicle, to come and actually work for us. So it is a way to attract them from that other side of the fence as well. Our industry doesn't receive rate increases based on the consumer price index or any other annual increase. The last time this industry came before this board and requested a general increase was October of 2014. And the amount of that increase was minuscule at best. Updating this tier system and giving us that 15-day trigger is going to ensure that we don't have to come before you and address a fuel surcharge unless there is an actual change in our metered rates by way of an application or an annual review of rates. So we won't have to be coming back before you anytime fuel reaches above 445. We are going to have these things in place, which makes the whole process much more efficient. And I believe that this is a measured response to what is, at this point in time, an ever-changing reality. Thank you.
Any questions?
Two questions. Ms. Knapp, the first question is, do you think?
It's given snatches.
Oh, sorry.
Then I'll answer it.
I wasn't invited, so I didn't know that.
Good comeback. Good comeback.
Do you believe that the TNC's ability to adjust fares in real time to account for gas prices, surge pricing, and all of those items, vehicles on the street is a significant competitive advantage over the taxi cab industry?
Absolutely.
Okay. Do you believe managing drivers, availability, drivers that employ, put on the street, fares that would be resulted from these increases, revenue for drivers and the cab companies, that this would be more or less competitive for the taxi cab industry and therefore competitive for you and convenient for the public?
Well, I believe it would make us even more competitive because anytime that we can provide better revenues to our drivers and better support, obviously that gives us an advantage. There's things that we can offer that the TNCs don't, but by allowing them to have a better share of that revenue, especially on the lease side, since they're going to get 100% of this, that gives us a great edge. As far as the writing public, I believe the writing public is used to fuel surcharges. We've had them around since 2003. And as long as we are transparent in what those fees are, we will take care of the signage at the airport at any of the tier changes. We've had the airport personnel come in before and complain that that wasn't timely done and wasn't of sufficient size to notify the public. Whittlesey and Henderson will take that responsibility to make sure that that happens timely and efficiently. I believe it gives us a better edge and that the writing public is not feeling that they're being, cheated by us in this regard.
Thank you.
I'd like to respond to that too. For sure, one of the concerns that is voiced from our drivers when it comes time that we're asking them to service any place other than the Golden Triangle is the price of fuel. So as we get an increase like this, it's nice for the driver to be able to go get a radio call, do something off that Golden Triangle because they are participating in the price of fuel. So this allows us to provide better service because we can do that. It just got brought up in Cheryl's conversation that I completely missed in my presentation, the flat rates. So I thought you didn't want them. We do. I'm sorry, Mike, I'm going to afraid that if you look at page 2 of the exhibit that we put in, we put some mileages in there. And then the page 3 of it is the actual printout that was provided to me from Captain, which is the, I think that you all are aware of Captain is the technology company behind our meters and our back end, I guess, management system. So I had asked them to get us this data from January 1st through March 15th. And they ran this to come up with these distances. So I didn't come up with these were come up with from Captain. So when we look at those, that the average distance from the airport to zone 1 is 3.69 miles. From the airport to zone 2 is 3.99 miles. And from zone 3, it's 4.98 miles. So basically 3.74 and almost 5 miles. So again, looking at kind of the average of those, the average is over 4 miles. So just like the average trip, which we were asking for 80 cents, here we would be suggesting that the zone rates go up $1, which is more than the 80 cents, But it's kind of coming back to us, again, asking you, we think that having them at a set dollar figure rather than starting to put them at weird numbers like 2180 is just better marketing and just easier for messaging everything. So we would be asking for increase from $1 to each of the zones, $1 increase to zone 1, 2, and 3. And we'd be asking that happen in each of the tiers.
So there's no divisibility problems with your meters on that one?
There is not. No.
Gotcha.
Well,
That one hasn't, so we've, to be perfectly honest, we could have those flat rates go up just 50 cents. But again, from a marketing standpoint and the signage and everything, we just believe that putting it at the dollars is what we are asking.
and the current fuel surcharge that was approved was done at $1 for each of the zones as well.
Yes. I apologize, I left that out of my presentation. Okay, Mike.
Good morning, Michael Balin, Yellow Checker Star, and all 4 new cab companies. We all have different business models. All of our drivers are employees. They're represented by 2 separate unions. The price of fuel does not affect our drivers' pay in any way. We pay for all of it. So whether it's $2 or $5, the company's losing money on it. So just to give you an example, in March, collectively, our companies did 1,642,857 miles. That amounted to 300. If we had a 20-cent increase, that would increase, or it cost us $328,571. So about $10,600 per day. So it's getting very expensive for us. And as far as the rates, we support everything that Cheryl and George said. As far as the flat rates, I can tell you, I've been in the industry over 30 years now. I never get a complaint. In fact, I got one last week. It was the first one I've had forever. And the gentleman was complaining because he wanted to run on meter because he thought it would have been cheaper. And the driver said, no, I have to run on flat rate unless you're making me stop. So it's the transparency of the flat rates. I totally agree with George, keeping it without any 50 cents, just keeping it a solid number definitely helps our industry. And people just love the transparency. So we definitely support a increase fuel surcharge.
Vice Chairman Thompson had the question about natural gas.
We do run on propane. It's gone up quite a bit. It's a byproduct of unleaded. Can't really tell you exactly because there's so many things that go into it. Our infrastructure, we have 8 fueling stations. We have 2 60,000-gallon propane tanks. It's very expensive to convert vehicles. Not only is there development and testing, then you have to get an EPA certification. So all that goes into it. Obviously, it burns a lot cleaner is one of the reasons we do it. But I couldn't really tell you exactly comparison between that and unleaded.
Well, okay, I was hoping you would say that the propane did not go up as much as the gasoline, which would encourage others to go propane. But
it's gone up.
What I'm hearing is that it's pretty much the same as gasoline.
The price is not the same, but when you factor everything that goes into it,
Well, you're going to pay everything that goes into it, no matter what. It can hurt in your car.
and part of this, obviously, our
We're
drivers.
looking at increases for the surcharge.
Correct.
So
Well,
that was my question.
Sure. Well, first off, a lot of our vehicles are not presently propane. We've had a lot of supply issues in getting that done. So all of the new cabs are not done. 100 of our YCS vehicles are not propane presently. And, part of this too is, as I mentioned, our drivers are represented by 2 unions. Mike Kilgo from the ITPU is here today, and the union would like nothing more to know what we pay per gallon. And we don't want to share that.
Okay. I'm interpreting your answer as though propane has gone up quite similarly to gasoline.
Yes, correct.
Whether that's correct or not, that's the way I'm hearing your answer.
You're correct. It's a lot more expensive than it was prior to these.
Okay, yeah, all right.
So follow-up, as to those vehicles operating on propane, you are saying they would participate in this same program?
Yes, sir. And that's the way it is right now, by the way.
And without disclosing data you don't want to disclose, do you have a sense of the percentage increase in gasoline versus propane? Is it?
I mean, I would be completely guessing here. I would say percentage wise, it's pretty similar. But that's a.
That was my interpretation of his answer. Whether it's correct or not, I don't know.
I didn't come prepared for that question. I'm sorry.
What percentage of your cars are propane?
Right now,
That are operating.
I would say, not as many, because none of the new cabs are, and there, we probably have.
50%?
It's gonna be less than 50% right now.
Okay.
We just, the last couple of years, we haven't been able to propane anything.
Less than 50% is a reasonable answer.
It's probably somewhere in that, pretty close to that.
Any board members have other questions for the applicant?
I have no questions.
I do not.
Ms. Favor Armstrong.
The only question I have, or information I have, the information is within your packets toward the end of the packet. There's a weekly retail gasoline and diesel price report. The only clarification we wanted to make was that when you use PAD 5 with California versus PAD 5 without California. That information in our data that you included was basically PAD 5 straight up.
Right.
With California. And I don't think we know whether you guys go to California to get your gas filled or not filled at this particular point, but those prices are a little bit lower than the prices in terms of us giving the board the data relative to the PAD 5 without California versus the PAD 5 with California.
Our historian will explain to you.
In the very beginning, when fuel surcharges were first addressed by the board, it was PAD 5, which included California, was the standard that the board voted on and decided would be the standard moving forward, as opposed to things like Gascoy and getting an average of facilities in our general area. There were too many variables. So the board made the decision to use the U.S. Department of Energy's PAD 5, including California. Because as so often happens, so many of our other goods that we purchase and we're vendoring with come from California, and those fuel surcharges would be passed on to us. Years later, at one point in time, a TA staff member did suggest possibly looking at changing the existing fuel surcharge board order and removing the California from the PAD 5 calculation. At which time the board then decided, and I believe this was at the August 2015 hearing, that if indeed they were going to look at changing the trigger, which was PAD 5, including California, then they would need to totally revamp the calculation of the 325 to 445 being $1, being the 20-cent fuel surcharge. The whole range would have to be looked at, and they did not want to take the time to do that study. And have the industry provide the data and try to relook at how that trigger would then have to be put into effect. So that's why it has been this way all this time. And the August of 2015 board order should reference that as well as the minutes from the hearing.
Mr. Chair, I have a comment on it. So this used to be actually on the Attorney General's website, regulates some gasoline type things, but Southern Nevada does not have a refinery of our own. We also don't have significant gasoline storage. So gasoline for Southern Nevada has to be trucked in from the nearest refinery or port, both of which are in California. So I'm not sure why we would want to take California out of it, since most of our gas comes from there, but I'm not an expert in petroleum.
All we're doing is just providing information for the board for their application in terms of what they want to do in terms of their consideration. We take no position on whether it's for California or not California in terms of situation that way. So fully support the industry in terms of what the industry needs to do in order to keep this high.
But as it stands now, the most recent order of 2021
What I understand.
continued the patent, including California. So we'd have to depart from that, which would require us to do a recalc of everything.
And it was one of the things that authority wanted to know. We allowed all the cab companies to do their own rate cards. For transparency's sake, we'd like to have this board state that there's a generalized rate card so that everyone knows transparency in terms of fuel surcharge rates and things of that nature, so that everyone knows what we're talking about, because some of the cards are a little bit different. And our concern is that we don't want confusing cards out there. So we would like to provide a form to the industry as to what we want in terms of how we would like the information to be displayed. If the industry doesn't have a problem.
We have no problem with that.
And that actually brings up an important point, Chairman Reeser and members of the board, about the 14-day, if you're inclined to approve that modification from a 30-day to a 14-day change, how do you expect the industry to respond to that? So historically, it's been whereby the agency would notify the industry that the gas prices have reached that threshold and been in effect for 30 days or more, and thereafter they're allowed to implement the fuel surcharge. This one is now, if approved again, 14 days. And so collectively, I think it would be helpful if we could address how you would like the industry to implement those, if you would like it to be on the industry to notify the taxi cab authority that it is the gas prices, as we have seen on this website, have reached this threshold, and then ask for permission, or again, that's a matter of procedural semantics, but I thought it would be important, since members of the industry are here, that we could discuss that.
Well, on that, Ms. Rushton, your application didn't really ask, you did ask to change the 30 to the 15 or 14.
Yes, sir.
But you didn't seem like the industry was having difficulty with the mechanism that we put in place in 2021, which is that the administrator would issue a notice that the threshold had been hit.
And that was my understanding after the August of 2021 hearing. You made that abundantly clear that it was not our responsibility to come before the board, that it was the authorities or the agency's responsibility to notify us.
And likewise, if the price of gas goes below, the administrator will issue a notice that you now go down to the next tier, or you don't have a surcharge if we luckily get to that point.
Yes, sir.
Is that a difficulty? Because
No,
we would prefer that.
that made it much more clearer for us.
We didn't have to think about it.
Because Member Soderberg, it wasn't a member at the time. So just for his edification, my desire at the time, when I made that recommendation to the board, was that the agency be controlling. It might be convenient to you. That wasn't my purpose. My purpose was that the agency would trigger when you went in and when you went out. There wouldn't be any, and I'm not accusing anybody in the industry of this, but I don't want any gaming of the system where somebody does it and somebody doesn't because they think they're going to take market share or something like that. So, I mean, because the statute requires that we have just and reasonable that goes across, all companies. There's not adverse competition. The companies created by some surcharge or other tariff structure. So.
And thank you for the clarification, Chairman. I thought it would be helpful for the administrator if we could just have that brief dialogue and talk about how that, and it also applies to the rate cards.
That's right.
Thank you.
And do any of the board members have any difficulty continuing with that? Any questions of Administrator Armstrong on the data you provided?
Nope. I have no.
Any further questions of the applicants?
Thank you.
Thank you. Any member of the public or industry that would like to address this on this matter? You're welcome to come to the table.
Just real quick,
Myself for the record.
my name is Desiree Dante on behalf of Lucky and Western Cab. I just want to actually thank the LOA and the companies associated with the LOA for taking the initiative on filing this application.
Any other member of the public? So I'll bring it. Did you ask?
No, sorry, just in conclusion, wanted to see if there were any follow-up questions, and otherwise, thank you. And express the importance of your consideration today. I think that the explanation that was provided in the application, as well as that substantiated by the carriers, demonstrates where the need is. But I also like the idea of having a record that is complete with respect to any time there is going to be a fee assessed to a member of the traveling public. And so the transparency of that, the calculations and the source of the information, I think is important again for our record. And then also, Chairman, with your permission, what I'd like to do is file a quick errata following the meeting just to correct the tier on page 2, and then we can move from there, just so that, again, we have a complete record. Or if otherwise you want to just recognize that.
No, I don't know that you need to file an errata. The record, I think, will be clear that at page 2, line 16 of the application, that sentence will be corrected to say $6.86 hyphen $8.06.24 cents fuel surcharge.
Thank you.
I don't think an errata is necessary to make that. You had your record, Ms. Rushton. Thank you, though. Opinions.
I will tell you the last media interview I did as the administrator of the agency regarding the comparison between Uber and Lyft fares a few months ago, but it was about the significant increase in Uber and Lyft fares in order for them to address their drivers on the road problems. And it had put the taxi cabs fares highly competitive compared to Uber and Lyft. The idea that they can in real time adjust their fares for gas prices, surge prices, crowds, lack of crowds, puts them at a highly advantageous position over the industry. Gibson noted that there was 2015 was the last time that this was addressed other than our amended order. So I would highly support approving, granting the application as requested and amended.
Thank you, Mr. Chairman. I don't see how we don't approve this. We're all aware of what's going on in the world. We're all aware of what's going on at the gas pump. That didn't require a hearing. What I was struck with when I was listening to this, and I've said before, the public is best served by a healthy industry, but I never really focused until in this last half hour that the financial health of the people who drive these vehicles is important to us as well. I've been in cabs in other towns, and the quality of our cab drivers is better. And it's very uncomfortable when you're in a cab when you don't, for lack of a better term, a quality driver. And I think this agency's done a good job of determining their fitness and making sure that everything flies well, but the companies have done so as well. We want this to be an attractive profession. And I know from having younger people in my family who aren't retired, it's competitive out there. And if you don't like it, if it's not a great job, go find another. We want this to be a great job for people, or for the public and for the industry. So I'm behind this 100%.
Well, Mr. Chairman, I would like a little clarification. Mr. Balaban spoke several times about raising the flat rate by $1. We're not discussing that here, right?
No, the application provides for relief on
It's the fuel surcharge.
but
Yeah,
by
that-
fuel surcharge,
All right.
by in two different ways. One, on a per mile basis, when they are not servicing a zone, those on a fixed dollar amount.
All right. So we are discussing
Yes,
a
both.
$1 increase in the flat rate.
The application requests relief in both.
Okay. I agree with both cases.
So I support the application. I will amplify on Member Serbrig's comment about this is not only for the certificate holders, but also for those who are employees. Yesterday, I had a driver who came to Nevada the same year I did and has been driving cab for 42 years for one of the companies here. And, you know, you don't get that and you want to keep that. And he was obviously a consummate professional in the way he kept his vehicle and the way he was attired. And I agree that has to be part of this. I will reflect for the record, you know, for those who might be listening to it or look at it. Yes, there is theoretically you might claim there's some over recovery on this, but I think that over recovery is not a dramatic percentage of the increase. It is driven in part by administrative convenience to be able to collect it, and it also reflects that the increase in fuel is not only what the companies are putting into the tank of the vehicle, but it is also being incorporated into the prices of the paper that they buy and the heat in the building and the, you know, bottled water or whatever, every other commodity or service that they're buying, those service or commodity providers are incorporating increased fuel charge, their experience into price. And so I think there's not an over recovery issue here in this surcharge. That theoretically there might be still an under recovery. We won't really know that for a few years till we see how this percolates through the industry. Also, a factor in my thought process is I think we have we are likely, given what economists are saying, not going to see this as a momentary event. This is more likely than not a reflection of both global economics, global unrest, and actually in long term, probably a payback for our dependency on petroleum, which we haven't yet as a nation been able to figure out a way to get away from totally. And that's going to be probably structurally part of the cost of doing business for the certificate holders. So I am confident there is not an over recovery problem here, and would support the application. And if there's no further discussion, would accept a motion to approve the application.
So moved.
Second.
Second.
It's been moved and seconded to approve the application. Is there any further discussion from members of the board? Hearing none, all those in favor signify by saying aye.
Aye.
All those opposed. So passed. Our appreciation, Ms. Rustin, for the application. We are to agenda item 7. I'm assuming everybody's still in the saddle and ready to ride. Okay. This is a presentation from Curb about upfront pricing for e-hail. Appreciate you coming. Identify yourself for the record. Go ahead.
Sure. I think with a good presentation. My name is Jason Gross. I'm the Vice President and head of the ride hailing platform at Curb Mobility. Athan Rebelos, Western U.S. Business and Sales Manager for Curb Mobility.
Thank you, gentlemen. Welcome. So we're gonna have to turn to watch something here.
We were hoping for your sake it would be behind us as well, but
sometimes this room is technologically challenged. Sometimes. Okay. Oh, he's done.
Okay, so again, thank you. We're Curb, and I know the administrator, Mr. Armstrong, is new, as some of the board members are. So I wanted to spend a few minutes just talking about who Curb is and what we do, and I think that'll provide good context for what we want to discuss and what experience we bring to bear in terms of that discussion. So Curb is a provider of a suite of services to the licensed taxi and for hire vehicle industry. And what we do in providing a common platform to taxis, either directly or through integration, is create a mobility network that, essentially, not to steal my later slides, allows taxis to operate in an aggregated fashion, common experience, common tools, common options. And we believe that's very important in maintaining the competitiveness with the Ubers and Lyfts that we've been discussing already at the meeting today. So just a little bit of the history. Again, we try really hard to act as nimbly as a startup, but we rely on decades of experience in the industry. So we were founded by a gentleman who's still our CEO, Amos Tamam, and it started out really in the meter business over 30 years ago, and moved from that into bringing credit card payments to taxi meters, both in the front and eventually in the back seat. We partnered with the company Verifone. And so if you've seen us in the past, we were Verifone Transportation Systems as part of the larger organization. And we had launched a ride hailing app called Way to Ride. It started out as a payments application. You can still use it here. And then we ended up acquiring what used to be Taxi Magic, is another app that people were aware of. We merged them under the name that they had recently used called Curb. And then we became private in 2018. So management, with the help of private equity, bought the company out from Verifone. And that allowed us to move a lot more nimbly. But I will say, for the record, we are not venture funded. So our approach to doing business is not nearly as aggressive. We're very regulator friendly. We help you guys properly regulate the industry. We help the taxi operators properly comply with those regulations. And we look to our ability to create technology as a way to bring the industry forward together in cooperation with the regulators for the betterment of the passenger public, the drivers, and the owners and operators of the vehicles. So again, what does that mean? We are all over the country, and in Canada, Mexico, UK, expanding globally. There are over 100,000 vehicles that are connected to the platform in more than 100 cities across the US. Pre-pandemic, up to close to 200 million trips a year, powered in one form or another through the platform. And as I mentioned earlier, we've been doing this a long time. So again, this is one of those cool little diagram slides, but essentially what we're talking about is the platform itself handles everything soup to nuts that a taxi operator may need, both with passenger facing options, fleet and driver tools to manage, and then the ability to move money and track that properly. So I think what's most germane here is what we've done with the rise of Uber and Lyft to not simply be a back office service provider, but also to present an option to the riding public and to other people in need of transportation to allow them to obtain transportation through a licensed taxi with all of the tools and the ease of use that they've come to expect from Uber and Lyft. So we do support consumer platforms, the Curb app, I'll talk about a little bit more. We have tools for corporations to allow their users to leverage taxis and have them automatically billed, provide rules and all sorts of accounting transparency that makes it a more viable option and more convenient for business users. Many of whom, of course, come to Las Vegas for conventions. We work with healthcare organizations, with hospitals, and other providers to help connect patients and staff at healthcare organizations to transportation. And then around the country, we work with various transit and paratransit agencies to, again, give them the opportunity to leverage taxis in an aggregated scale that they haven't had access to before, except through, I think, some technology they often use to manage their buses and then try to broker trips to individual cab companies rather than simply saying, Mr. Jones needs transportation right now. All of these providers are authorized to provide that transportation at this particular moment. What's the best vehicle? Not which fleet should I give this to for them to find what is their best vehicle. So in terms of what we have from a passenger facing perspective, there's the app you can download for iOS or Android. We have a web portal that allows hotel concierges, staff, administrators to book rides for multiple passengers. We have a 24/7, 365 call center that we don't expose to consumers, but we expose to corporate accounts, to government agencies, and on a select basis to people who would benefit from having access to phone booking, if for no other reason than they are not smartphone savvy. We have a host of API integrations to third-party partners, and I'll talk about that a little bit more at the end. We have a customer-facing web booker. So one version of that is a QR code. So if you can now go to a restaurant and scan a menu, you could scan a code, put in where you want to drop off, enter your credit card information, and book a cab without ever having to download an app. And the last is, I think you guys have known a version of this as the button here in Las Vegas. There's another one we partnered with called Taxi Butler. Essentially, it's an ability for someone to put a button on a hotel, someone to press the button and a cab to, unlike the button, it has a display, it tells you what cab's coming. And we've rolled that out in various markets around the US in partnership with Taxi Butler. The mobile app, again, we are, to our knowledge, the largest taxi app in the US. We're in 20 major markets. We have historically been in more, but what we're really focused on is, as I mentioned earlier, providing a common experience. So we see a lot of people coming to Las Vegas or New Orleans who are coming from New York or Washington, and we want to make sure, I think this is a mistake made by Taxi Magic years ago, that wherever you open Curb, you're going to get a similar experience. You're going to know what you're in for. That's what people expect. So inside the app, again, a little bit of an overview. We actually do use black cars in New York City now, and that's simply because they're fully licensed. They're not TNCs. We want to provide as many options as possible to our user base, which has really grown substantially, at least by our measures, over the last couple of years. We have an option for accessible cabs as well. What we're going to talk about a little bit later is the upfront pricing. This is a screenshot of what you see as you're booking a ride. We try to, given our payments history, we try to support as many different types of payment as possible. So that can be Apple Pay, PayPal, your credit and debit cards, or as I mentioned previously, a corporate account or a paratransit account. And we do all the fancy math if there's subsidies involved and make certain that everybody gets what they're expecting out of the experience. And the last option, which I think we see a lot of, and this is why I say with the taxi line, as efficient as it is at the airport, I'm not here to ask you to let us e-hail taxis at the airport, not that that's your domain, but people get out, they see a number on the back of the screen, they punch it in and they've appified that trip. They pay for it with their card on file. If they have access to subsidies, they're applied, they get a digital receipt or it's billed to their company. But it makes that old fashioned street hail at the taxi line at the airport or in front of one of the hotels more mobile and more efficient, bringing as much of that kind of frictionlessness as we can to an experience that starts with hopping in a cab. Again, we've actually seen a real uptick, and I'll talk about the upfront price, what I think that's meant for this. But again, as you all just discussed, from going public through the pandemic to fuel, Uber and Lyft across the country have become substantially similar in fare to taxis before surge. And one of the things we find is there are definitely two camps, and we're going to talk about this a little later, between should taxis surge, or is the fact that they are predictable pricing something that is important enough to a significant segment of the population that that itself is a competitive advantage. And there's no perfect answer to that, in my humble opinion. So for fleets and drivers, again, about Curb, the company, we provide a suite of tools. And if you get into a taxi in Las Vegas, you're going to see basically one of two devices in the front of a cab. One of them is what we call the Dash, just an Android-based tablet that's provided by Curb. And in the other cabs, you'll see Captain, as I'm sure you guys are familiar with. In the back, you will, if it has a relationship with us, you'll see what we call the marquee, which is that 7-inch screen facing the passenger in the headrest. And again, it supports the payments we talked about. It shows information of the passenger, and it can work with either of the two systems in the front.
So a little bit of a larger screen here. Again, it's ADA compliant. It shows that 7-digit code that allows someone to pair with the trip. It can show infotainment as it has in various times. And it allows us to display additional information based upon what we or you think is compelling to the customer. Taxi TV, again, is the last piece of the company. We used to, may or may not know, manage the actual wrapping of cabs and the taxi tops here in Las Vegas. We actually sold that business to a partner called Firefly. So we've exited that, but we still maintain control of the screens in the back. And we run those in multiple markets around the country. So the reason we came here, upfront pricing for taxi. A little bit about what we do. If you're at all familiar with taxi meters, as I'm sure most of you are, they work on time and distance, but the time is time and traffic. And so it's calculated after the fact. Have I moved? Have I been over the threshold of 10 miles an hour, whatever you set it at? What we do is we take the same concept of a base fare, a price per minute, and a price per mile, and we run algorithms against the historical data that we have from billions of records of taxi trips, and we try to be, with a formula, as close to what the meter would be for that similar trip. It's not perfect, but the intention is to leverage that information to provide a base that is effectively what the meter would be in advance. Traffic can change. We don't change the price after the fact for traffic. We do change it if the passenger requests to change the drop off, and that's communicated to and accepted by the driver. And most importantly, we do not right now surge in any meaningful fashion. There are places where the meters have surcharges for rush hour overnight. There are things we do to try to make the fares reasonable. And we are, again, a service provider to drivers and medallion owners and operators. Our goal is to help them present the product that best delivers what they want and what consumers want. But we don't take the consumer's position. We're not a consumer company. We are a driver and fleet company. And so our goal is, if we're not queuing perfectly to that line, we're up a little bit above, because we want to make sure the drivers don't have individual trips where they feel like they're getting jammed up and this is less than a meter. And if we go to the next slide, what the driver sees, unlike a typical TNC driver, is here is your fare. Depending on what's done, if there are tolls, tip, and surcharges that we don't know, we're telling them it will be plus those things. Usually how the meter works. If it's added separately from the fare on the meter, then it's added separately from the fare on the upfront case. We give them the time, the distance to pick up, the pickup and the drop off, and the fare they will own. And so it's as best we can, complete transparency to the driver. It is their choice. We do not run a program where we say drivers who do not accept jobs will be penalized. That's not our MO. It's about providing options to drivers and manifesting those options to passengers who also receive an upfront fare quote that is binding. And what it allows them to do, as you might expect, is compare the price for that taxi ride at that moment with Uber and Lyft. 5 years ago, wasn't going to be pretty. Now it is. And so what we've seen is, since we launched this, the first 3 markets, New York City, Chicago, and DC, we've been up 1,000% in usage of the app to book cabs. And what we see anecdotally is there are a lot of price shoppers. There are people who appreciate the fact that we don't surge. And we see spikes typically when you would see Uber Lyft surging and their PTAs have gone way up, we see a spike in it. We don't promise everyone a ride every time at any price. We say, this is what a taxi costs. We will try to get you one. And people, especially locals, learn where and when they're going to be able to get a cab because it's predictable. But we are seeing that we change driver behavior because we're generating incremental demand in areas where it's a little bit harder for them. This is with no disrespect to the traditional dispatch operations. That's a bread and butter of our business as well. But there are people off the strip looking to get transportation. I think Las Vegas has done a wonderful job of creating opportunities for tourists to leave the strip to do interesting things. We're seeing a little bit more demand, but what's difficult to do is to communicate to passengers, hey, this is a viable alternative from a price perspective as well. And what we're hoping to do is have a discussion around what would it take for us, in your minds, to get something approved. And then, of course, we have to talk to the operators, right? There are clients and there are constituents as well, but we wanted to surface the idea to you. And it seemed very timely in all the discussion around how the fares themselves are much more competitive. This has been our ace in the hole to make passengers aware of that fact. To the degree that you follow the news, there's been announcements by Uber that they're working with us and with other taxi companies or dispatch system providers to bring taxis into their ecosystem. I wanted to comment on it. I'm not here to propose anything with that respect. Curb, as I mentioned before, is a platform, and we look at both sides of the equation and say, how can we aggregate the most of both to create a marketplace where, with a price that is regularly approved, we're allowing them to find each other. So we have we have our systems in Nellis and Lucky and Western, through our integration with Captain, eHail a cab from YCSA cab to Luxury cab. And we have a bunch of integrations on the consumer side. So Transit is like one of those multimodal apps that'll tell you, take a bus to here and get the train over to there. And then if you need to walk or take a taxi, we think of Curb as, on our best days, as a stand-in term for taxi. So you'll see sometimes we don't need our name to be there. We just need people to know that they can get a taxi. So we have these apps where people can find a taxi ride. We have integrations to corporate booking platforms, where again, they don't need another app, they just need a taxi in the app they have. We work with healthcare software companies and providers to connect and bill properly for healthcare reimbursed rides, and we work with transit agencies. So on the next slide, this is what a couple of our existing integrations look like, and conceptually what an Uber integration would look like. It's simply, in my range of ride options, I want a taxi. If I select a taxi, that ride request is sent to Curb, just like Expedia sends your booking request over to Delta. And we are a licensed provider of dispatch technology, and we provide a regulated user experience for the driver and the passenger. And if there's an app that wants to connect us so that we can connect that passenger to cabs, we're open to. That's generally our approach. We want to make certain that the interests of the drivers and the fleet owners are protected in as much as we can, and certainly with the help of the regulators in determining what is a reasonable way to do so. But again, as I said, I'm not here to really pitch you on that, but I wanted to make certain that because it's in the news, you understood what our feeling is about it. I think that's it from a presentation perspective.
I have one. Obviously, you're making money on those. How do you charge your cab companies?
Sure. So when it comes to the eHail, I can stick to that if I may for a moment. There are a few different ways. We've historically, for hailing a ride with the app, charged a disclosed service fee. So when we're using the meter, there's a $1.95 service fee. It works out to roughly 10% of the fare. What we have found, and again, I can't prove this other than the anecdotes, is people hailing a cab start to look at their receiving T line and say, why did I pay this? So when we went to upfront pricing, we took that service fee and we bundled it with the fare. So there is a small gap between what the passenger pays and what the driver receives. It's known in advance, those two values to each party, and we're not in the 30-35% business of Uber and Lyft, but there is a cost to maintain the platform. And what we want to do is focus passengers on the ability to, if it's not a fee from you guys, it's not broken out. This is the cost, compare this to Uber and Lyft. The driver, here's what you're going to get. You should compare this in your mind to the meter. And everybody should be okay, and no one is faulted for not wanting that trip at that price.
Did I hear you say that it was approximately 10% of the fare, total fare?
It depends. I mean, it depends somewhat on how the regulation is structured in the city. But today in Las Vegas, if you use the app, there's a $1.95 service fee regardless of what the fare is. So that in our minds is sort of what the average is we're looking for in order to fund the project of doing so and, compensate us as well. We have a lot of staff. that it takes a lot of work to manage something like this. Even though we don't advertise widely and do as many of the fancy things, we can change the price. If you guys change the fare, just like we can in the vehicle on the meters, they're digital, we can do it in the app. If you decide that we want to collectively do things for the industry and it's fair to everyone, that prices should be a little higher at night, we can do that. But we have not taken our technology and decided that we should use it in that fashion because we believe that the value proposition to the consumer should be, it's a consistent price every time I open the app. I'm not gonna have sticker shock.
So it's about 70% coverage of Las Vegas area. Is that what I saw?
75%.
No,
We cover 100% of the Las Vegas area.
No, I mean, of the cab companies.
75%.
Cabs.
75% of the medallions in Las Vegas have our system.
So if I were a cab company, I would try to balance out, what do I get from this and what do I pay for this, et cetera.
Right.
So, okay, that answered my
Yeah,
question.
and in terms of the software and the payment processing, those are much like, Captain or others, they're just business deals with the fleets for providing a service. I think how many, 75% have the marquee in the back?
Yeah, right. 75% of the cabs have the marquee in the back, which enables them to be available on our app.
We are able technologically to provide an app for drivers to put on their phone. Our strong preference is to have it go into the single mounted device in the vehicle that knows whether the cab's on duty or not, en route to a dispatch pickup. It's a much better experience and it's safer. But there are markets in which it's necessary and allowed to do it on an app. So when you see that Android tablet, it's running traditional dispatch, it's running a meter, it's running a driver, but it's on the same tablet.
That's all I have.
No, so is there a pending request from the board or are you expanding this?
What I think we would like, we wanted to present to you about this and hear any of your feedback. And I don't have a motion for you to vote on, but if there's an openness to this concept, then I think it'd be incumbent upon us to work with the operators and come back with a proposal to
The upfront price.
join. Yeah.
Gotcha. Right. And I suppose that would be the company would officially request it. Have to ask that question.
Yeah, and we wouldn't do anything without the buy-in of the company. They're our primary stakeholders.
Would you, so I guess I do have one. Would you say that most consumers, most passengers, those TNCs are used to pulling up an app and getting an upfront price, or is that something, an advantage?
When we've had, favorable tailwinds, right, throughout this time, but we can see the inflection point. Don't spend millions of dollars on advertising. What we end up doing is we launch this, we email our users about it, we text them, and we do a tiny bit of awareness advertising, in the cabs or on Facebook or Apple search, things like that. So the minute that we've gone to upfront pricing, that's when we see the usage take off.
Yeah,
So
I
I
guess that's
agree
what
that to be, that's what people want. And anecdotally, we hear, what I don't like is it appears that some people will book in both apps and whoever comes fastest or has the best ETA, they'll cancel the other. So we're kind of implementing a cancellation fee for passengers so we don't burn the drivers. But yeah, it's been really well appreciated. We get nothing but compliments on the fact that the price is not the way they're treated by Uber and Lyft, and that it's cheaper. Again, you can always hail a cab on the street, traditional way, you pay the meter, you use the app. Yes. But the idea is you could.
No, you have to preset a location pickup.
Yeah.
You can't just say.
Or walk out to the taxi. But you can get in, you can pay the meter. We don't want to deprive people of that option, but from the app itself, we feel like people have grown to expect if I open an app to book transportation, I'm gonna get a price and that's what I'm gonna pay. And that's what we're trying to do, is provide that option in the same fashion at a substantially similar quality and a lot of the time at a better price.
I have no question, Mr. Chairman. I want, there's one part of the presentation I have a slight disconnect, so I'm walking through. You said your algorithms are good, but they're not perfect. So there's I take that to mean there's a delta of some sort between what the algorithm generates and what the tariff rate would be. Is that correct? Right. It may be up or maybe above or below.
Yeah, yes.
Correct. How does your technology address that issue when there's a tariff?
By tariff, you mean like a?
There's a set price by the government. So right now we set a price, that's what they're gonna charge. And the app says it's gonna be 45 cents more.
The challenges that I mentioned earlier, that we don't know how much of the drive time would have put into idling on a meter. There's no way to know that. So when you see on an individual, the 20 minutes of drive time may have been compacted into 10 minutes at 60 miles an hour and 10 minutes at a standstill, right? So we look at the data, we continually look at the data. When we hear back from drivers or passengers, this doesn't sound right, we continue to look and we update the formulas basically to make certain that nothing has changed in the way that just, if traffic is worse, right, than it was, during the pandemic, those algorithms may need to be adjusted. When you guys make tariff changes, they need to be adjusted, but our goal is to basically be in line with the meter. But what we're looking for is preferably not something that says, hey, the rule is you have to be and be able to demonstrate that you're within 2% of the meter. The point of that really is that is in our minds a goal to make this fair and reasonable. But in a perfect world, and as we've seen in other jurisdictions, there's not a hard and fast rule that says in order to do upfront pricing, it must be X. In fact, for example, in New York City, it was give us a base formula and a maximum multiplier of that formula or divisor of that formula. So you'll never go below 50% of what your kind of meter target is, or you'll never go above 300% above what that meter target is. As I mentioned, we've made a branded business decision not to use those tools. But I would say it would be, in Philadelphia, they said you can charge, I think it was maybe 10% above what that meter calculation is. And they went and did road tests. And they basically used the app. So we're flexible, but I would say giving flexibility to us in the industry, as long as there's transparency, would be optimal. But it's not in our nature to want to abuse either side of the marketplace, but depending on how you would do something, I would recommend enough flexibility that we don't unintentionally create a case where we're breaking a rule that was overly restrictive, but we're happy to have guardrails, right? We think that's good and proper.
Yeah. Could you provide to the administrator like an example of the 3 best ordinances or regulatory solutions you've achieved in other jurisdictions?
Yeah, we can do that. And forgive me, there are ones where they're pilots, where they were written as a pilot and go forever, but we'll get you some language. Sure, absolutely.
I think we'd be interested in seeing what kind of legal mechanism another authority is used to get to this result.
Sure.
Because we may or may not have statutory authority to do that.
And there are definitely a few ways. It's been like a metaphors day, so I won't go with one, but there are definitely a few ways to accomplish that.
I'd like to probably to that. I'd like to talk to you further about it too.
Sure, we'd be happy to.
So I'm not sure, subject to the pleasure of the board, I'm not sure that we need to take any action. I would encourage, I think this is a positive, and I would encourage Herb and the certificate holders to have a dialogue and see if you've got traction here or not. But the traction, I think, at least speaking as one member, is going to need to come from certificate holders. This isn't something I think the agency would push down on certificate holders if they didn't want it. But
Appreciated.
other sense of the board.
I agree that.
Okay. Very good. Thank you very much.
Thank you for your time, guys.
That brings us to agenda item 8, which is industry discussion. Says matter is on the agenda for us to receive input from the industry on things that are going on, and somebody's here.
Just one second. Rich Frakes from Desert Cab. Thank you, Mr. Chairman. I just wanted, we know that the mask mandate got lifted federally. So of course, all the cab drivers are asking.
The answer to your question is that we sent out a press release yesterday that specifically stated that the last night mandate is no longer in effect for any of the cabs, either for the passengers as well as the drivers.
Okay.
So disregard the thing that's in our website that specifically says that it's still enforced. I'm still in the process of trying to figure out a way to remove that from the website, but that may take some time.
Okay. We didn't get that.
Yeah, so
we didn't get that.
The press release went out yesterday telling the industry and the right and traveling public that it's that so long as that order remains the law, we're following the law.
All right.
Right?
Yes.
Yeah. Anything else from the industry?
Oh, I didn't get it.
Brings us to agenda item 9, which is staff reports. And our first report is from the administrator.
I have only been on the job 2 days, so to a certain extent, there isn't a lot of things that I would want to say to this board, except thank you for giving me the opportunity to be the administrator of the agency. Basically, what you'll find within your board packet is our statistics for them, as well as the information as to what we've accomplished, and what I would defer at this particular point to the chief investigator as to enforcement operations that we've had during the month and up to date as of this point. I'm in the process of familiarizing myself with the agency, as well as the people, the staff, and the challenges that we need to deal with at this particular point, and hopefully we'll have a more detailed report for you and next board meeting.
Perfect. Chief Investigator.
Yes, I think it's good afternoon.
There, yes, we're there.
Chairman and members of the board.
There by 2 minutes.
Ruben Aquino, Chief Investigator for the record. I just wanted to start off by thanking Member Decker for his professionalism, his dedication, and the efforts he's made and the sacrifices he's made the last over 365 days to lead the TA agency. And to Administrator Armstrong, I look very much forward to serving underneath you, and I think coming at a great time, and we're moving forward. So with that being said, I wanted to start off my report with investigator recruitment status. I reported last time I was here that we had currently had 8 investigators. We're going to currently will have 9 by this coming Monday. So we have a new investigator starting. So that brings that total number up to 12. And I previously said 8, will be 9. There's 3 that are currently inactive on the payroll. As far as recruiting, it's ongoing and continuous. We have 2 investigator candidates that are currently in backgrounds, and we anticipate finishing those up here fairly shortly. So hoping to bring that number 15, the position patrol numbers, up to what the legislature has approved. And I could take questions now in regard to the recruitment, or I could just defer everything and just wait till the
We'll
end.
ask you all our questions at the end.
Very good. Next, enforcement activity. So obviously there has to be a balance of the activities that we do between patrol activities, as well as the very hot topic of unlawful passenger transportation here in Southern Nevada. So we are the enforcement unit is always operating in that fifth gear, trying to make that balance of doing patrol enforcement activities as well as UPTs. So I just want to reassure the board that we're continuing our uniform operations as well as undercover operations for violations under 706 AAC NRS, as well as the unlawful passenger transportation. So I want to touch on that just a little bit, just to provide you with something that we're looking into. We've been seeing a trend in regard to unlawful passenger transportation. Obviously, as I explained to this board before, we have a lot of Craigslist type of UPTs. We have a lot of folks operating on the street when we do our undercover operations. But we ran into something that was really interesting, something that I've not seen very often, an organized UPT situation where they're booking online, they're booking on an app, and someone is directing, dispatching unlawful passenger transportation. So something I just wanted to bring up to the board. We're looking at that pretty heavy. I'll obviously brief the new administrator on this, and we'll be consulting as well with the Attorney General's office in regard to some sort of enforcement. We were successful recently in a sting operation where we discovered this information along with other resources that we have. And then lastly, I want to talk about really quick special events, something that's coming up, as everyone knows in the room, the 22 NFL draft and the experience is going to happen next week. Those dates on that is Thursday, Friday, and Saturday. Those are pretty much all day events. So immediately after this meeting, the administrator is hosting a meeting with the industry in regard to some of the specifics in regard to the pickup and drop off points for the taxi industry. Someone came in late just now, and it's Lisa Motley. She's with the Las Vegas Convention Center. She's going to be briefing us in the meeting afterwards. So we're on top of it. It's pretty exciting. You know, we don't know what we don't know. It's a new venue, a one-time venue. Don't know how many people are going to be there, but certainly the taxi cab authority is going to be there in full force, and whatever we could do to help out the riding public and keep them safe. And then lastly, I want to talk about Electric Daisy Concert, which is scheduled for May 20th through the 22nd, which is a high volume transportation, passenger transportation for Southern Nevada. So again, we are participating in talks with Las Vegas Metropolitan Police Department, as well as the host of EDC in regard to best practices, where to set up the pickup and drop offs for those types of passengers. So with that being said, that's all I have for now. If you have any specific questions for me in regard to those topics, I'm happy to answer them.
Any questions of the chief investigator?
I think they have a meeting to go to.
Huh?
I think they have a meeting.
Yeah, I think that we're telling
We're going to hold
telling
a
us to
meeting.
move it along.
We're going to hold a meeting after this meeting.
Yeah.
Thank you.
Thank you, gentlemen. Thank you.
Anything in particular you want to, we have our statistical reports. Is there anything?
If you have any questions, we can go through
Any
in terms of that.
questions on the statistical report? Anything from Dag Bala or Mr. Rick?
Nothing from me, sir.
Mr. Rickard, do you have anything that we need to know?
Yes, three things. Good morning, Mr. Chairman, members of the board. David Rickard, administrative attorney for the agency. Three things, Mr. Chairman. Number one, I'll get to work on drafting both those orders. I would propose to do the fuel surcharge one first, simply because I think it's more immediate application for the industry.
Right.
Second, I did want to say welcome and introduce to the board, Michelle Lewis Zahir is a new employee of our agency and legal secretary trainee.
Welcome.
And she's been great. I expect great things from her, and we're very happy to have her. So I did want to do that. The third thing, without delving into it, but I did want to let the board know for future agenda items. There will be an appeal to the board on previous decision made by me as a hearing officer, has recently been filed. So that was all.
Thank you very much.
Thank you.
Are there any future agenda items any member of the board would like to have considered, or the administrator?
The only thing that I would want to talk about is I would like the industry to provide us comments as to how they want the bad administrative code revised, because we want to have the hearings relative to those regulations done in a package as opposed to just doing one at a time. So if the industry has any questions, concerns, or things that they want to see changed, please let me know, and we'll see what we can do to draft that and have those hearings so that we can get those regulations out to you guys.
So Ms. Martinez, will you put that on as a specific agenda item for May? And in that connection, Member Decker will help me because I have flagged, since I joined in July, a few such items that I would like attended or suggest we attend to. So we'll get you a list of those items, but we'll take comment next meeting. Ms. Rushton, did you want to speak on that matter?
Yes, sir. Just briefly. For the record, Kimberly.
Pen and a paper, you're ready to go.
Yes, sir. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson. I would just note that I think that the consensus of the industry is that there are a significant number of regulations that need to be reviewed and possibly amended. And I would respectfully submit that perhaps another workshop would be in line. I think it would give the industry an opportunity to have more of an open dialogue before we bring proposed final regulations before this board. The other thing too, just because of the enormous cost associated with pursuing regulatory workshops, one more I think would be helpful. So again, we're not too disjointed in how we proceed with these for LCB and then the continuing process.
Well taken. While he was still serving as interim administrator, Mr. Decker and I had a conversation on the second workshop and decided to defer it until after Administrator Armstrong's appointment, because we thought it would be helpful for him. But I think we will consider the scheduling of an additional workshop, but I think also we'll put on the agenda for those who might not be able to participate in the workshop, an opportunity to give us a laundry list at the next meeting.
Yes, sir. Thank you.
Chair, I might propose that we change the order. And this is just a proposal, but if the industry works with the administrator to come up with the list of regulations, but I know industry has probably a longer one than the agency does, and they come up with a draft document that we can then at the board workshop and then come to some agreement. It might provide some kind of draft document prior to it getting to us, as opposed to us trying to run that process.
We'll do whatever it takes in order to work with the industry in order to make it happen.
Well,
right now, go ahead.
We haven't decided that's going to happen, but
are you suggesting that we hold the workshop first, or are you suggesting that there be informal dialogue first and then the workshop?
I'm suggesting that the agency work with industry in informal dialogue prior to them presenting items to us in a workshop, which we can then, and that possibly the agency is in a better position to collect all of that data and come up with a draft document.
You good with that?
No problem.
Okay.
Yes, sir. Thank you.
Any other future items for consideration? Great. That brings us to agenda item 10. This is a time set for our second public comment session. This is set aside for members of the public and industry to provide comments to us on matters that are within our jurisdiction. No action may be taken, but we would love to hear and welcome any industry comments. Is there any member of the public who would like to address us? Seeing none, we'll close public comment, and I will entertain a motion to adjourn.
So moved. Second.
Any discussion? All those in favor signify by saying aye.
Aye.
Thank you. We'll be